Hi, this is Ed Sullivan and Mark O'Berty with O'Berty Sullivan LP, an employment law firm in Houston, Texas. Mark, on June 25th, the Supreme Court granted certiorari, meaning they're going to hear the case, is Vance versus Ball State University, which I think a little trivia is where David Letterman went to school.
True.
And the issue there is who is a supervisor under Ellerth and Faragher, which are basically two Supreme Court cases that discuss affirmative defenses available to employers in sexual harassment cases. Why don't you explain what's going on?
Yeah, okay, so the sexual harassment, or I guess any harassment, hostile environment claim, they draw a distinction between coworker harassment and supervisor harassment. And for coworker harassment, the plaintiff has to show that the employer knew or should have known about it and failed to take prompt and effective remedial action. On the other hand, if it's a supervisor who committed the harassment, there's automatic vicarious liability subject to an affirmative defense that the Supreme Court created and set forth in Ellerth and Faragher. So the question is posed by Vance versus Ball State, well, what is the definition of a supervisor? How do you delineate between a supervisor and a coworker? In a lot of cases, it's obvious, but there's a bunch of cases out there where you have a person who's above the plaintiff in the chain of command, and in some of those cases, they only have the authority to kind of boss them around on their day-to-day duties, but they don't have the power to hire or fire, promote, or demote. And so what's happened is a circuit split is developed, and there's been, I think it's the 2nd, 4th, and 9th circuits have said, well, even if the person above them doesn't have the power to hire or fire or make an actual adverse decision, if they're just supervising their day-to-day activities, that's good enough to make them a supervisor. On the other hand, the 1st, 7th, and 8th circuits said, no, not good enough. Even if that person can boss them around and tell them what to do on a day-to-day basis, if that person doesn't have the power to hire or fire or demote or promote them, well, then they're not a supervisor for purposes of this Ellerth-Faragher hostile environment analysis. That's what the 7th Circuit said in this Ball State case, and they threw out the affirmative summary judgment in the employer's favor. So now the Supreme Court has granted cert. They're going to decide this issue, and it's an important issue because, once again, if you have coworker harassment and they decide, well, a person like this is just a coworker, well, now the plaintiff has to show knew or should have known and failed to take prompt and effective remedial action. On the other hand, if they determine that someone who has this type of authority, even though they can't hire or fire, they're actually a supervisor, well, then the company's automatically vicariously liable subject to their affirmative defense. So it's an important case, and it'll be decided next term, and keep your eyes on it.